Hello and welcome to A Seat at the Sitting for October 2024. I'm Nate Kazmarek, Vice President and Director of the Practice Groups. It's great to be with you and our distinguished panel as we look at the upcoming oral arguments at the Supreme Court this month. Before we begin, I'd like to flag for our audience that next week, on October 8th, the Federal Society is pleased to convene our first ever conference devoted to artificial intelligence. The theme of this in-person and virtual conference is the future of law in an AI world. We expect a full day of great new scholarship and thought-provoking conversations. To learn more or to register, please visit our website, fedsoc.org. Turning to the business at hand, in the next 90 minutes or less, we are looking forward to an excellent preview of the upcoming SCOTUS docket. As surely you know by now, the usual disclaimer applies. Opinions expressed during this opinion are those of the speakers, not FedSoc itself. Regarding today's moderator, my own opinion is that she is both a great person and a great lawyer. And we know that outside of the Federal Society membership, those two things don't often go together, or sometimes don't go together. I'm delighted that she could carve out time to help guide our conversation today. Welcome, Kirby West. How are you today?
Thank you very much, Nate. I'm great. I'm happy to be here.
Well, as I said, I'm delighted to have you with us. I'm looking forward to you guiding today's conversation. Kirby is an attorney at the Institute for Justice and the co-director of IJ's National Initiative to End Forfeiture Abuse. She litigates cases protecting property rights, First Amendment rights, and educational choice. She has litigated educational choice cases in state and federal court, including the United States Supreme Court, where she was a member of the IJ team that won the 2022 ruling in Carson v. Macon. Her law degree is from Harvard Law School, and her undergrad is from Bucknell University. Before joining IJ, Kirby was at Baker Botts, and she previously clerked for Judge Dennis Shedd of the U.S. Court of Appeals for the Fourth Circuit. More complete bios for Kirby and our other experts are available for your review on our website. This panel will cover the upcoming cases, and then we'll go to audience Q&A. So please craft your questions in advance to try and stump our experts. We are live on many of the Federal Society's platforms this afternoon, but if you have joined us by Zoom, your questions can be submitted through the Q&A function at the bottom of your screen. And we will, as always, we will answer as many audience questions as we can. With that, I think the table is sufficiently set. So Kirby, I will hand it over to you.
Thank you very much, Nate. As I said, I'm delighted to be here and with this very distinguished panel who each deserve a far more lengthy introduction than I just received. And I'm going to give them short shrift and give them a pretty brief one each so that we can get to the meat of the day. We're going to go through 5 cases in order that they'll appear before the court this month in some detail. And then after that, I'll touch on the remaining 4 that will be before the court this month in, very briefly, about, 30 seconds for those remaining 4. But the panel that we have with us to discuss the cases today, in order of appearance, we have Matthew Rice, who is the Solicitor General of Tennessee right now, formerly of Williams and Connolly. We have Zach Smith, who is the Senior Legal Fellow and Manager of the Supreme Court and Appellate Advocacy Program at the Heritage Foundation's Meese Center for Legal and Judicial Studies. We have John Maslin, who is Senior Litigation Counsel with the Washington Legal Foundation. And finally, closing us out will be James Burling, who is the Vice President of Litigation at the Pacific Legal Foundation. Thank you guys all so much for being here, and we'll get right into it. And I'll turn it over to you, Matt, to start with our first case here out of the 8th Circuit.
Sure. Thank you all so much for having me. I'm excited for this term to get started and excited to talk with you today about a fun civil procedure case that will be heard on the first day of arguments, Royal Canin versus Wullschleger. This case involves 2 closely related questions related to removal. As you all probably remember from your civil procedure class, if a plaintiff files a complaint in state court, a defendant can remove the case to federal court if the complaint contains a federal question. The issue here is whether a federal court has to remand the case if a plaintiff, after removal, amends their complaint to eliminate any federal question. Specifically, the questions presented are: 1, whether a post-removal amendment defeats federal question subject matter jurisdiction, and 2, whether a post-removal amendment precludes a district court from exercising supplemental jurisdiction over the plaintiff's remaining state law claims. So this case arose out of a dispute over dog food. A plaintiff filed a complaint against several pet food manufacturers in state court. The complaint raised state law claims, but in setting out those claims, it mentioned federal statutes. The manufacturers removed the case to federal court, arguing that the references to federal statutes establish federal question jurisdiction. The plaintiff then proceeded to amend her complaint to drop all references to federal statutes and move to remand, arguing that there was no federal question and thus no basis for supplemental jurisdiction over her state law claims. The district court declined to remand and ultimately granted the defendant's motion to dismiss. On appeal, though, the Eighth Circuit vacated that dismissal and ordered remand of the case to the state court. The court first concluded that the amended complaint did not raise any federal questions. It then reasoned that because an amended complaint supersedes an earlier one, the lack of any federal question in the amended complaint deprived the federal court of jurisdiction, both federal question jurisdiction and supplemental jurisdiction. So the parties' dispute in this case resolves around the proper interpretation of several well-known jurisdictional statutes. The federal question statute, 28 U.S.C. section 1331, states that district courts shall have original jurisdiction to hear civil actions arising under the laws of the United States. The supplemental jurisdiction statute, 28 U.S.C. section 1367, in turn gives federal courts supplemental jurisdiction over certain state law claims in any civil action of which the district courts have original jurisdiction. So the defendant argues that when a case is properly removed, the federal court has original jurisdiction, and even when the federal question has been removed from the complaint, the court retains supplemental jurisdiction over state law claims. If the rule was otherwise, the defendant argues, then the plaintiffs could engage in forum manipulation. The defendant, on the other hand, argues that an amended complaint replaces the original for all purposes. Once the complaint is amended to remove the federal question, then there's no original jurisdiction under 1331, and a court can only exercise supplemental jurisdiction over state law claims when there is original jurisdiction that can be supplemented. So the plaintiff here also pulled a very unexpected move in the response brief. The lead argument, which takes up almost 30 pages, I believe, according to the reply brief, is a request for the Supreme Court to overrule an earlier decision interpreting Section 1331's arising under language, Grable and Sons versus Giroux Engineering. Currently, under Grable, courts apply multi-pronged tests for determining whether a case arises under federal law for purposes of Section 1331. They analyze whether the state law claim necessarily raises a federal issue, whether that issue is disputed and substantial, and whether a federal forum can entertain the suit without disturbing any congressionally approved balance of federal and state judicial responsibilities. The plaintiff, presumably prompted by Justice Thomas's separate writing in Grable, says that the court should reconsider that multi-pronged test and return to the old rule for determining whether a claim arises under federal law. Under the old rule, courts simply asked whether federal law created the cause of action that was being asserted. The plaintiff, I don't believe, asked the Eighth Circuit to overrule Grable because it couldn't. And I don't believe it raised this issue in the bio. So we will see if the court has any appetite to engage with this question. Tennessee filed an amicus brief in this case, joined by a bipartisan coalition of 21 other states. Our brief argued that two interpretive canons favor the plaintiff's reading of the relevant statute: one, the constitutional avoidance canon, and two, the federalism canon. So our constitutional avoidance argument rested on the limits of Article 3. Article 3 extends jurisdiction to cases arising under the Constitution or under the laws of the United States. That language was interpreted in Osborne versus Bank of the United States to cover any case with a, quote, federal ingredient. Now, this is the same language, this arising under language in both Section 1331 and under Article 3. But as you probably recall, the court has adopted different interpretations of these phrases. So we argued that the defendant's proposed rule could run afoul of even the looser interpretation of Article 3, because under the defendant's rule, a federal court could, at least in some circumstances, retain a case that has no federal ingredient. So imagine if there were two pure state law claims and one federal claim. If a case is removed and the federal claim is dropped, then all that remains are the two pure state law claims. And that case doesn't seem to have a federal ingredient, yet under the defendant's view, it would stay in federal court. Generally, federal courts must maintain Article 3 jurisdiction throughout a case, so we argued that the constitutional avoidance canon cut against the defendant's interpretation. Second, we relied on the federalism canon. Generally, the Supreme Court requires exceedingly clear language from Congress before it interprets a federal statute to displace a traditional state power. And the court has historically sought to keep the task of interpreting state law squarely in the hands of state courts. So we argue that it should do so here because Section 1331 and 1367 do not clearly displace the state court's power to resolve state law issues. So even without these canons, I think plaintiff and Judge Strauss's opinion has the better reading of the statute, but I may be wrong because I think almost all the other courts of appeals have come out the other way, and I think there's quite a bit of precedent coming out the other way over the past few decades. So I'm looking forward to seeing how this plays out. Really looking forward to seeing whether the request to revisit Grable gets any traction or is ignored altogether. And that's all I have on this one, and I'm looking forward to our discussion. So thank you, guys.
Great. As some of you have already realized, I should have noted to please use the question and answer feature if you have questions for any of our panelists. Feel free to put those in as things are progressing so that the cases are fresh in your mind, but then we'll come back to those questions at the end of the various presentations. But thank you very much, Matt, for getting us off to a great start there. And I'd like to turn it over to Zach, who will be talking about the next two cases that'll be before the court this month, Garland and Glossop. Zach, what do you got for us?
Well, thanks for that introduction, Kirby. I appreciate it, and I enjoyed listening to your summary as well, Matt. So I'll start with the Vanderstock case, which is going to be argued on October 8th, and then I'll spend the bulk of my time probably on the Glossop case, which will be argued the next day on October 9th. Now, the Vanderstock case, if you've been following the news, is the so-called ghost gun case, where the ATF has the authority to regulate ghost guns under the Gun Control Act of 1968. Now, to a certain extent, you may be thinking this case is deja vu all over again. And the reason I say that is because a similar issue was before the court last term in Garland versus Cargill. You may remember that's the bump stock case, where essentially the ATF issued a very expansive regulation defining machine gun in such a way that would cover bump stocks, which are not a machine gun under the ordinary definition of how machine guns function. And of course, in a 6-3 opinion by Justice Thomas, the Supreme Court agreed and essentially upheld the vacatur of that ATF regulation. Well, this time in the Vanderstock case, the ATF has once again promulgated a series of regulations that has expansively defined firearms as well as receivers and other parts of a firearm in such a way that it will give them authority to regulate many things that they did not traditionally have the authority to regulate. And so under the Gun Control Act of 1968, Congress has the authority and did impose licensing, background check, record keeping, and serialization requirements on people engaged in the business of importing, manufacturing, or dealing in firearms. Now, the Gun Control Act of 1968 itself contains statutory definitions of a firearm. It says, quote, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive, as well as the frame or receiver of any such weapon would qualify as a firearm under that act. Now, from the passage of that act from 1968 until 2022, the ATF had essentially interpreted the firearm definition, as well as the frame or receiver portion of that statute in a similar fashion. There may have been some ambiguity about what was included, but generally everyone understood that it had to be a firearm that could be readily converted. And as a guidepost, many people point to that parenthetical that's included in that statutory definition, such as a starter gun. And from my understanding, starter guns with very minimal machining in a matter of 10 to 20 minutes can be converted into a operational firearm. And so that's what most people understood that readily convertible language to include. Well, in 2022, the ATF amended their regulations, taking, once again, a very expansive definition of readily convertible and applying that readily convertible language to also modify frame or receiver, which it does not modify in the statutory definition. Now, Judge Reed O'Connor in Texas, which initially heard this challenge, agreed with the challengers that the ATF had overstepped its boundaries in promulgating this new regulation. The Fifth Circuit Court of Appeals ultimately agreed with Judge O'Connor, both on a preliminary injunction matter as well as on the merits. And so now the case is back before the Supreme Court. When the Biden administration first came to the Supreme Court, asking the court to essentially stay the vacatur of the rule while they appealed it, in a 5-4 decision, the Supreme Court declined to do so. So it'll be very interesting to watch and see how the justices line up in this case. Again, last term in the Cargill case, it was a 6-3 decision where the Supreme Court overturned the ATF's regulation on bump stocks. And so we'll have to wait and see what happens in this case as well. Another angle to this case that the challengers to this rule are raising is they're also making a rule of lenity argument. And the reason they're making that rule of lenity argument is they say that the Gun Control Act is itself a criminal statute. And because it's a criminal statute, any ambiguity or vagueness should essentially be interpreted to the benefit of those who may be punished under this statute. And the reason they say, the petitioners, the challengers to this ATF regulation say that this statute is too vague is they say that readily convertible language, in the way that the ATF has interpreted it, it's so broad that it encompasses firearms and firearm parts that can be converted into an operational firearm or to a frame or receiver in a matter of minutes, to everything that's going to take potentially hours upon hours, as well as very sophisticated machinery to convert as well. The ATF promulgated a series of factors, 8 factors, I believe, that is supposed to guide people in helping to understand whether their items could be readily converted into a firearm or into a frame or receiver. And yet those factors, again, are so broad, so expansive, that the challengers to this rule say they really don't provide any guidance at all. So this will certainly be a very interesting case to watch, and we'll have to wait and see whether the same lineup from the Garland versus Cargill, the bump stock case, will also weigh in the same way in this Vanderstock case as well. So with that, I'll move on to the Glossop versus Oklahoma case. Now, to understand what's happening in this case, this is essentially a death row inmate who is seeking to have his conviction vacated. And to understand the background of this case, we have to go all the way back to January 7th, 1997 at the Best Budget Inn in Oklahoma City, Oklahoma, where unfortunately a very brutal murder took place. On that day, Justin Sneed brutally murdered the owner of the Best Budget Inn, Barry Van Treese. Now, Justin Sneed at that time was a 19-year-old methamphetamine addict who, it turned out, was also suffering from bipolar disorder at the time he beat Mr. Van Treese to death. Now, Justin Sneed worked at the Best Budget Inn along with Richard Glossop. Now, it's undisputed that Richard Glossop did not actually murder Barry Van Treese, that Justin Sneed committed the murder, but the state argued at the time that they arrested Mr. Glossop that he essentially had planned the murder and had essentially put Justin Sneed up to the act of murdering Barry Van Treese. And the rationales for why they say he did it has shifted over time. At one point, the state said Mr. Glossop was afraid he was going to be fired. Later, they said it was because he was trying to get material benefit from Mr. Van Treese's murder. But it's undisputed the state believes that Mr. Glossop essentially conducted a murder for hire. in this case. So they arrested Mr. Glossop. He went to trial initially in 1998. He was convicted and sentenced to death for his involvement in this murder. He appealed that conviction, and the Oklahoma Court of Criminal Appeals overturned it. They said Mr. Glossop had not received effective assistance of counsel in that first trial, so the state decided to retry him, and in 2004, he was once again convicted and sentenced to death. Now, the problem in that latter conviction, that 2004 case, is that there were a lot of evidentiary issues. There were allegations that the prosecutors did not turn over all of the required evidence. There were allegations that the prosecutors committed Brady violations, which, as any criminal practitioners know, is essentially the requirement that you provide any exculpatory evidence to criminal defendants. And so for many, many years, Mr. Glossop's attorneys had sought to receive more information from the state, whether there was more exculpatory evidence out there that was not turned over. And because of Mr. Glossop and his attorney's repeated requests to this extent, because of some of the information that came out, there were several investigations outside of court proceedings into the conduct of this case and Mr. Glossop's claims related to prosecutorial misconduct. In fact, in June of 2021, an ad hoc committee of the Oklahoma State Legislature commissioned a report from the Reed Smith Law Firm. The Reed Smith Law Firm, that report alleged numerous instances of prosecutorial misconduct. Because of that, in January 2023, the Oklahoma Attorney General initiated his own investigation, ultimately agreed to turn over additional evidence to Mr. Glossop's attorneys. And so what happened is, after the Oklahoma Attorney General began looking into this matter, in August of 2022, 7 additional boxes of information were turned over to Mr. Glossop. 8th box was withheld as attorney work product, but that box also was eventually turned over to Mr. Glossop and his attorneys. And it turned out that as part of that additional information that was turned over, some prosecutorial notes were included that seemed to indicate that the prosecutor who was in charge of that 2004 retrial of Mr. Glossop knew that some of the information that Justin Snead testified to was inaccurate. It seemed to indicate that the prosecutor, at least according to Mr. Glossop's attorneys, had colluded with Mr. Snead's attorneys to line up his testimony with some of the physical evidence, perhaps in a contradictory way to what he had indicated to investigators right after his arrest. And again, a host of other allegations as well. And of course, the reason Justin Snead testified against Richard Glossop is he received a favorable deal in exchange for his testimony. And so after reviewing all of this evidence, after seeing all of this information, the Oklahoma Attorney General ultimately agreed with Mr. Glossop's attorneys that his conviction and the death penalty sentence should be vacated. So when Mr. Glossop filed his petition with the Oklahoma Court of Criminal Appeals, the highest criminal court in the state of Oklahoma, that court disagreed. And they actually upheld his conviction and upheld his death sentence under Oklahoma's Post-Conviction Procedure Act. Now, the Oklahoma Post-Conviction Procedure Act is modeled after the Federal Anti-Terrorism and Effective Death Penalty Act, DEPA, and there are certain procedural requirements in place in that Oklahoma Post-Conviction Procedure Act that says a successive petition for relief, essentially a successive habeas petition, can't be granted unless at least 2 conditions are met. And I'll just read those to you. It says the application must contain sufficient specific facts establishing that the current claims and issues have not and could not have been previously presented in a timely original application or in a previous successive application, because the information upon which they're based was essentially unavailable at the time of those previous applications. And they also, petitioner bringing a successive petition also has to show that the facts underlying their new claim, if proven and viewed in light of the new evidence, would be sufficient to establish by clear and convincing evidence that but for the alleged error, no reasonable fact finder would have found the defendant guilty of the underlying crime. And essentially, what the Oklahoma Court of Criminal Appeals said, they said neither of those conditions had been met. And in part, they said that those previous conditions had not been met because they disagreed with Mr. Glossop's contention that there had been a Brady violation, that the prosecutor had withheld potentially exculpatory evidence. And then Mr. Glossop also brought what's known as a NAPU claim, NAPU versus Illinois, which essentially says a prosecutor cannot knowingly put on false evidence. And so Mr. Glossop said because of some of the testimony that came out about whether or not Justin Sneed had previously seen a psychiatrist for bipolar disorder, Mr. Sneed testified he had not. The prosecutor did not correct that, that was a NAPU violation as well. But the Oklahoma Court of Criminal Appeals, again, disagreed with that and said the prosecutor had not knowingly supported false testimony. And so now at the U.S. Supreme Court, we're in the highly unusual position of the state of Oklahoma supporting Mr. Glossop's petition for the Supreme Court to take up the case, supporting his position that his sentence and conviction should be vacated. And the court, of course, because of that, has appointed amici to represent essentially make the argument to uphold the conviction below. Now, you may be wondering if there are so many problems with this case, why doesn't Oklahoma's governor just pardon Mr. Glossop or commute his sentence? Well, the pardon procedures in Oklahoma are somewhat unique. There's a commission that has to essentially recommend commutation. It's a 5-member commission, but one of the members of that commission was actually the husband of the prosecutor that prosecuted Mr. Glossop in 2004. Because of that, he recused from this case, and that split 2-2 on whether or not to recommend a commutation. Now, there are 4 questions presented in this case. The question presented that I think is most interesting and maybe the focus of argument is whether or not the Oklahoma Court of Criminal Appeals, its interpretation of Oklahoma's Post-Conviction Procedure Act, whether that itself constitutes an independent and adequate state ground that can be used to uphold this conviction and essentially deprive the Supreme Court of the ability to review it. So it'll be a very interesting case to watch. I suspect it will take a lot of time at argument. The facts of this case all around are problematic on many fronts, but it'll certainly be a very important decision in post-conviction relief and criminal procedure going forward.
Well, thank you so much, Zach, and thank you especially for pulling double duty for us there and talking about both of those cases. With that, I'll turn it over to John to talk about medical marijuana versus Horn.
Thanks so much, Kirby. It's great to be here and to be discussing the beginning of the October term 2024. Medical marijuana v. Horn is a civil RICO case. Horn is a commercial truck driver who was injured in an accident in 2012. He injured his hip, his shoulder, and his back. Because of the pain, Horn took Tylenol, Motrin, prednisone, and hydrocodone. As he was still experiencing pain, he turned to natural remedies. While Horn and his wife were at a bookstore coffee shop to kill some time before eating at Chili's, they saw a magazine called High Times. Now, I'm personally unfamiliar with the magazine, but it is the preeminent source for cannabis information. Horn was very familiar with the magazine as he had previously used marijuana. On page 42 of the magazine was an article describing Dixie X, a hemp-based CBD product that is dissolved under the tongue. The article claimed that Dixie X was CBD-rich medicine and contained, quote, 0% THC. Despite never talking to a doctor, the Horns were confident enough that Dixie X contained no THC as to purchase it. Soon after, Horn was chosen for a random drug test, which are obviously required under Department of Transportation regulations and his employer's policies. Unsurprisingly, he failed the drug test. He was given the option of participating in a drug rehabilitation program and keeping his job, but he declined to participate in that program and was fired. Horn and his wife sued the makers of Dixie X under the Racketeering, Influenced, and Corrupt Organizations Act. The statute provides that, quote, any person injured in his business or property by reason of racketeering activity can sue for treble damages. The district court granted the defendant's summary judgment motion because, in its view, lost earnings or wages are not recoverable in a civil RICO suit if they flow from a personal injury. Here, the district court said that Horn suffered a personal injury when he ingested the Dixie X that contained THC. Horn and his wife appealed to the Second Circuit, who, splitting from other circuits, held that Horn could sue to recover lost wages if they flow from a personal injury suit. All parties agree that personal injuries are not actionable under civil RICO. The defendants argue that for that exclusion to mean anything, plaintiffs cannot bring civil RICO suits for damages that flow from personal injuries. In other words, they argue that plaintiffs cannot make up the lack of a qualifying injury by pointing to damages to business or property that result from a personal injury, even if those damages are economic in nature. According to the defendants, the Second Circuit's approach displaces state tort law because plaintiffs could bypass state tort reform by always suing under federal RICO for ordinary personal injuries. Horn's response is a bit difficult to understand, but the gist of his argument is that injury, quote, is just the other side of the, quote, damages point. According to him, the fact that the word damages is plural in civil RICO is key to understanding the meaning of the word. He views that as meaning that the damages that somebody suffers is the same as the injury that the person suffered. The Second Circuit's rationale, however, was a bit different. In its view, the fact that the definition of racketeering activity includes a list of crimes that typically only cause personal injuries suggests that Congress wanted plaintiffs to be able to recover for damages suffered as a result of personal injuries. In other words, the Second Circuit held that there is a superfluidity problem if you bar these types of suits. For example, murder and kidnapping are included in the list of predicate RICO offenses. The Second Circuit thought that those crimes would not have been included if plaintiffs could not recover for injuries to business or property that flow from personal injuries. Now, Washington Legal Foundation filed an amicus brief in this case, and it focused on this superfluidity problem that the Second Circuit apparently identified. The problem with the Second Circuit's argument is that RICO has both civil and criminal enforcement penalties. They use the same definitions for what is a predicate RICO offense. The difference between the two statutes is that there need not be an injury to business or property for the United States to bring criminal charges. In other words, Congress decided that it wanted the executive to have prosecutorial discretion when only personal injuries resulted from racketeering activity. The Second Circuit did not cite, much less discuss, these criminal enforcement provisions. The Washington Legal Foundation's brief also describes how there are ways to murder or kidnap someone that injures business or property. For example, if you blow up a car trying to kill somebody, there's damage to property there, and you could theoretically sue under civil RICO because murder was the predicate offense. Of course, the Second Circuit did not discuss that either. The second part of Washington Legal Foundation's amicus brief in this case discusses the due process concerns. Again, RICO is both a criminal and civil statute. Furthermore, RICO provides for treble damages. Therefore, under the court's case law, defendants are entitled to heightened due process protections. Defendants have no clue what they could be held liable for under civil RICO if any personal injury that eventually leads to injury to business or property can be included in a civil RICO suit. So essentially, they're not on notice of what activity that they could be held liable for under civil RICO. This case is really important for businesses around the country because if SCOTUS adopts the plaintiff's argument, there will be virtually no limit on the potential liability for minor state torts that are going to be filed in federal court under civil RICO. This will certainly be an interesting oral argument because you have Lisa Blatt, who is representing the defendants, and so we know how fun it is to listen to her argue.
Well, thank you very much for that, John. I especially appreciate it. I confess to being oft mystified by the ins and outs of RICO suits. So I appreciate that breakdown for us. With that, I'd like to turn it over to James to close us out before I touch briefly on the remaining cases with an interesting case from San Francisco versus the EPA.
So here is a case where San Francisco, which is a bastion of liberal politics, is suing the EPA, which everybody on the right despises, that everybody on the left generally loves. But to understand why we have this lawsuit, I have to go back to the predecessor of the Clean Water Act. Back before we had the Clean Water Act in the early 70s, there was a standard anti-pollution act, the Water Pollution Control Act, that made it illegal to, quote, cause or contribute to the reduction of the quality of water quality standards. So you could have a stream or a lake with a water quality standard saying that the level of pollution should be below X, and anybody who could cause or contribute a violation to that standard could potentially be liable. But it was really, really hard to find cause and effect. And as a result, there were only a few dozen prosecutions, and it really did not do much at all to clean up the waters of the United States, thus the Clean Water Act. And the Clean Water Act had a new and unique mechanism. It adopted effluent limitations for enforcement. It set water quality standards for water bodies, and the states would work with the EPA to set a water quality standard of so much bacteria, so much copper, so much of various types of pollution. And it established these effluent limitations, and they were to be technology-based. That is, you couldn't have a limitation that was absolutely impossible to meet. But the court said that it is illegal to discharge any pollution into a water of the United States unless you have, from a point source, unless you have a permit under the National Pollution Discharge Elimination System permitting. I'll just call them NPDES permits. So you get yourself a permit, which is based on effluent limitations, or limitations as the case may be, and we'll get to that distinction in a moment. But it's based on certain limitations that are technology-based. In other words, it's based on the maximum of what you can do. Let me give you an example. I'm going to go back completely apart from what's going on in San Francisco to about 35 years ago when I lived up in Alaska. In Alaska, I represented gold miners who were having all kinds of problems among other people, the Environmental Protection Agency. And now the way that the gold miners worked is that they took a stream and they diverted water from the stream, and that water went to a series of sluice boxes where the miners would take with backhoes and other heavy equipment, gravel up to the sluice boxes. The water would slosh down through the sluice box, separating the gold from the other rocks and sand and that kind of thing. And then the water would go into a series of settling ponds. At the end of those settling ponds, maybe a few hundred yards up to a quarter mile away, it would go back into the stream. Now, at the end of the settling pond, EPA set effluent limitations. That is, water leaving the settling ponds had to be clear. It couldn't be turbid. And there were turbidity standards, and the miners groused about this. They didn't like these standards. They complained that sometimes the water coming from the stream itself is dirty if there's been runoff or other miners upstream. But that didn't matter. The EPA said, look, we don't care about that. We just want to have clean water going out of the discharge. And the miners would say, well, that means sometimes we have to make the water cleaner coming in than it is going out. The EPA again said, no matter, and the courts eventually agreed with the EPA that you have to do it. And one of the reasons was it was fairly easy to determine whether or not you were in violation. In that case, you take some water, put water in a tube, and this is a glass, it's not showing, there it is. Glass is not showing up, and you shine a light through that glass, just like that. And depending on how much light gets through the test tube of water, you know if you're in violation or not. So let's fast forward to San Francisco today. San Francisco, big city, and it has what is called a combined sewer outfall process. That is, it has its sewage that goes into the sewers, but also stormwater drainage also goes into the same system. That can be a problem when it rains. And it was a huge problem for a long time. And the San Francisco averaged about 114 overages in a year. That is, every time it rained and for a while after the rain, all the sewer water would get combined with the stormwater drainage and there would be overflows, which is as bad as it sounds. San Francisco spent hundreds of millions of dollars to upgrade the system, and now they only have about 8 exceedances of overcapacity a year. But under the current permit standards, they are told not that they have effluent limitations per se, that is a quality or how much bacteria, a numerical standard of how much bacteria or how much of other pollutant can go into the water of the United States. They're essentially being told that in addition to any of those, you cannot, under the standards, you must not cause or contribute to an applicable violation of a water quality standard in a receiving water. So we're back to the pre-Clean Water Act, must not cause or contribute to a violation. And this sort of ambiguity gives EPA maximum discretion for enforcement because it's really hard for San Francisco to know whether it is violating the Clean Water Act permit or not, because it depends on the receiving water. If the receiving water is really clean today, then you can put junk into the waters. You can discharge a whole bunch of stuff because you know that the waters are going to stay relatively clean. But if the waters are already dirty, on a particular day, storm runoff from elsewhere or multiple sources that may be polluting, then EPA could be in violation even if what it puts into the water is pretty clean. So EPA is saying we can't tell really if we're in violation or not. We think we should have only strict numerical standards on effluent limitations, not these narrative standards that we can't cause or contribute. Well, the EPA first tried to do the internal appeal process within EPA. It didn't work. And they went to the Ninth Circuit. And in a 9-1 decision, the EPA lost. There was a dissent by Judge Sutton. He said this kind of ambiguity and enforcement, ambiguity and understanding whether or not you're in violation, it's arbitrary and capricious. And therefore the regulation is unlawful. But that was only a minor position. So EPA filed a cert petition. And in their cert petition, EPA said, look, this is like the sword of Damocles holding over our heads because we don't know if we're in violation. And we could potentially be sued for hundreds of millions of dollars by an environmental group or the EPA for violating the Clean Water Act when we really don't know what we're in violation of. Now, the ironic thing here is between the time the petition for cert was filed and the time that San Francisco filed the reply brief, EPA fulfilled the prophecy of San Francisco, and EPA sued San Francisco, asking for hundreds of millions of dollars in damages for violation of the effluent standards that EPA had imposed, the narrative not cause or contribute. With that, the city of San Francisco had a field day in its reply brief saying, see, we told you what was going to happen, and indeed it did happen. So the Supreme Court, not surprisingly, granted cert. And the question presented now is whether Clean Water Act allows the EPA to impose generic prohibitions for exceedances of water quality standards without identifying specific limits to which discharges must conform. Now the briefing has been done, and a lot of it comes down to an interpretation of the language of the Clean Water Act. The section dealing with NPDES permits talks about limitations. It doesn't talk about specific effluent limitations. And this distinction between limitations and effluent limitations, which would be the numerical standards, is key, because EPA is saying, look, if Congress wanted to put a requirement that the NPDES permits have numerical effluent limitations, it could have done so. In fact, when the Clean Water Act was being debated, the Senate had a version that would have required these numerical type of effluent limitations, but that was not adopted. See, that means that Congress did not intend it. And when Congress says have limitations in the NPDES permits, we're doing just fine because we do have limitations. The limitations is not to cause or contribute, and it doesn't have to be these specific numerical standards. And so our parties are arguing over the structure of the EPA, the history of it, and so on and so forth. So I think it's going to be a fascinating argument on October 16, where the court's going to have to wrestle with the question of statutory interpretation and whether or not the interpretation should be guided by the rather draconian force of the ambiguity in the EPA standards. So with that, I'll turn it back to you.
Thank you very much, James. I'll confess, when I read the QP for that one, I didn't know if I agreed with you that this is going to be a really interesting case, but you sold me. I think this is a pretty fascinating issue. I want to remind everybody to keep the questions coming in. We're going to turn to questions in just a minute, but I did briefly just want to touch on the remaining 4 cases that will be before the court this month that we haven't discussed yet. Also, apologies, my webcam conked out on me here halfway through, so I've got a new camera angle. But very briefly, on October 7th, the court is going to hear a case out of the 11th Circuit called Williams versus Washington. Now, this case deals with a doctrine called exhaustion. So other public interest lawyers, including the ones on the panel here, will know that if you're suing the government, there are a number of possible pitfalls that can trip you up in a civil rights suit against the government. And one of these is the doctrine of administrative exhaustion. That is, have you pursued all of your administrative remedies before you're bringing this case to the court? Now, there's a case from the U.S. Supreme Court from 1982 that says if you're in federal court, you do not need to exhaust state administrative remedies to bring a 1983 suit. But in Alabama, the Alabama Supreme Court recently said in a case involving petitioners filing unemployment compensation claims that they did need to exhaust administrative remedies before bringing their federal constitutional challenge to the Alabama State Court. And that's because under Alabama law, the courts don't have jurisdiction over these claims until there's a final decision from the Alabama Department of Labor. So the question in Williams is going to be, does this rule, Patsy versus the Board of Regents, which is the 1982 case on exhaustion of administrative remedies, does that also bind state courts to hear these kinds of claims without requiring petitioners to exhaust all of their administrative remedies? The next day, on October 8th, the court is going to hear a case called Lackey versus Stinney. And this case is about the availability of attorney's fees after 1983 suits. So as many of you may know, Section 1988 says that for parties that prevail in a 1983 suit, there's attorney's fees can be available to those prevailing parties, quote unquote, prevailing parties. And the question in Lackey is essentially, what does it mean to be a prevailing party in a 1983 suit? The court has already said in the past that if a party, for example, wins a preliminary injunction, but then later loses the case, that party is not a prevailing party. In essence, the party has won one battle, but they didn't win the war, so they're not a prevailing party for purposes of attorney's fees. In Lackey, however, you have a situation in which the petitioners who were convicted criminals who challenge Virginia's requirement that driver's licenses be suspended if there's any outstanding court debt, like fines or restitution or anything like that. They challenged that in a 1983 suit and won a preliminary injunction, but then the state of Virginia repealed that law. So by the time the court is then considering the petitioner's suit, having already granted them a preliminary injunction, now the suit is moot. And so the court dismisses the case. And the question here is, have they substantially prevailed? They got what they wanted, but ultimately, even though they did win the preliminary injunction, it never was adjudicated to a final decision by the court. So the court here will decide what does it mean to be a prevailing party for attorney's fees under Section 1988. On October 15th, the court is going to hear a case called Buarfa versus Mayorkas. This is an immigration case, and it's about whether a visa petitioner can obtain judicial review when approved petition is revoked on the basis of non-discretionary criteria. Now, that sounds a little bit confusing. Essentially, what happened here is that green card holders can apply for visas for their immediate family members. And here, the petitioner did apply for a visa for an immediate family member for their husband, and that petition was initially granted. And that decision would have been reviewable later by a federal court, by the immigration court. But after the petition was granted, it was later revoked because of new information that came out about the petitioner. And Congress has now foreclosed judicial review of purely discretionary immigration decisions. So the granting of the petition in the original action would not have been one of these decisions that's non-reviewable, but the revocation of it is a decision that's wholly discretionary and under the new rule, non-reviewable. So the question here is, does that make sense? And should that be the rule, where you have a situation where the petition was initially granted, and it would have been reviewable, but now when that petition is later revoked because of new information that wasn't before the decision-making body in the first instance, it's not reviewable, and should it still be reviewable? And then finally, we have a Veterans Affairs case, Bufkin versus McDonough. I'm not sure if I'm saying that correctly. That will be on October 16th. And the question here is, Zach talked earlier a little bit about the rule of lenity, and essentially the VA also has kind of a statutory rule of lenity for veterans. There's a statutory rule called the benefit of the doubt rule that says for veterans claims, the veterans should get the benefit of the doubt when it comes to kind of close factual decisions. And the question in this case in Bufkin is, does the benefit of the doubt rule mean that the Veterans Court is only required to review VA factual findings for clear error? Or does it have to do a closer review that looks at whether the veteran actually received the benefit of the doubt from the VA in the claims determination on close factual issues? And so that's rounds out the cases that will be heard this month in the court. And again, I welcome people to continue bringing those questions in, but we do have a few to get us started. Matt, the first question is for you, and that is, assuming that the court in this case takes on the Grable argument, can you articulate that argument a little bit for us?
Yeah, sure. So under the current test, it's a multi-pronged test to determine whether there is a sufficient federal issue in the case that looks at what is the federal issue, is it disputed, is it substantial, and how does it affect the relationship between state and federal courts. And so before that test was applied, it was a much simpler test. The test was, it arises under federal laws if it arises from a federal cause of action. And so the plaintiffs say that was the correct test, and that it's kind of by accident that we've kind of progressed further and further away from that understanding of what it meant to arise under federal law. And the place where we've gotten to is one where they have some statistics that some scholars have provided, but on this issue, on this multi-pronged Grable test, they claim that 55% of federal district court decisions are sometimes overturned. And so they're highlighting essentially the unworkable nature of this kind of amorphous multi-pronged test, and claim that when you have jurisdictional rules, the court has stated over and over again that we want clear jurisdictional lines, and they're advocating for a return to the clear line. Does this arise under a federal cause of action? I'll be surprised if the court engages with this request to overrule precedent, though I think at least a few on the court would be interested in doing so. It was brought up in the response brief, and one of the things the petitioner points out in the reply is, the United States has a large interest in this issue, but because it was only raised in the response brief and wasn't raised below or wasn't raised in the bio, the United States did not file an amicus brief in this case. So, yeah.
Great, thank you very much.
Sure.
Zach, the next question is for you about glossip. And it is, apparently there was I missed this, but a two-part post in Volek saying that this case is a fraud by both of the parties in regards to the alleged Brady violation. And our questioner wants to know if you have any comments about that.
Yeah, so it's actually a three-part post now. It's written by Paul Cassell, who also filed an amicus brief on behalf of Mr. Van Treese's family. And this will also tie into another question that I see is whether the Oklahoma court's decision really depends on a conclusion that Glossop's Brady and NAPU claims lack merit, whether there can be an independent state ground regardless of the outcome of those decisions as well. So look, in terms of the Brady violation, I think Paul certainly raises some very real, very interesting issues. It certainly seems like the Attorney General in Oklahoma took the least generous reading of the prosecutor's notes. And what's interesting, Paul includes in his post and the court-appointed amicus, or representing the integrity of the conviction, essentially, actually post pictures of the prosecutor's notes. And if you look at them, they're very stream of conscience. They're very, like question marks, kind of the thought bubbles interspersed throughout them. And so essentially the argument is that the defense already knew about this information. This wasn't new information that the prosecutor was trying to conceal in some way. So it's a very interesting brief by Paul. I encourage everyone to read it. And then in terms of the second question, whether the Brady and NAPU claims, whether there can be an independent and adequate state ground, regardless of those claims, there's also an excellent brief filed in this case by the Criminal Justice Legal Foundation, essentially making that argument. I think that is something the court is going to have to grapple with more and more. One of the interesting undercurrents in this case is how much, if any, deference should courts give when prosecutors confess error. And this is something that more and more courts are having to address, particularly as more and more prosecutors, particularly so-called progressive prosecutors, come into office around the country, where they've placed a large emphasis on reviewing previous convictions. This has been an issue in Texas, I know. There's a previous case, the Escobar case, where this issue came up. Texas filed an amicus brief on this issue as well. So it's a very interesting issue. And just from a practical perspective, if you read the state of Oklahoma's brief in this case, which was done by Paul Clement, essentially part of the undercurrent of the brief is that the Attorney General of Oklahoma has supported the death penalty in other cases, just not in this case, because of the factual circumstances surrounding it. So trying to distinguish maybe the Oklahoma Attorney General from some of those other prosecutors who are just anti-death penalty across the board. But very interesting issues and likely to have a big impact on post-conviction proceedings, particularly in the death penalty context going forward, no matter what the court decides.
Yeah, I agree. That's a really interesting issue for death penalty cases. Our next question is for you, John, about the medical marijuana case. And our questioner wants to know if one possible outcome of this case is that if a plaintiff wins under RICO, if a plaintiff loses wages due to a car accident, they could sue for treble damages under RICO. And they say if that's so, there's no way the court would do that. And what do you predict the outcome of the case will be?
Well, I wish there was no way that the court would do that. But there is a case called Sedema v. Imrex, where the court said that RICO was Congress's attempt, quote, to strike at organized crime, end quote, but that, quote, in its private civil version, RICO is evolving into something quite different from the original conception of its enactors. So the Supreme Court has continually given RICO a broader interpretation, a plaintiff-friendly interpretation that its text will really support. If I had to guess on the outcome of this case, I think the court might try to split the baby here and say something about proximate cause and say that if the personal injury is a natural result of the predicate RICO offense, that then you can sue for personal injuries. But if it's not a natural cause, then you can't sue. I find it hard to believe that either side will get a completely clean win in the case.
Our next question is for you, James, and that is, will San Francisco, a liberal city, as the commenter points out, arguing in effect for a reiteration of Loper-Bright here?
So first of all, in EPA, when it defends its statutory and interpretation, and which it says supports its regulatory regime of imposing something other than numerical effluent limitations, it doesn't ask for any kind of deference as a la Chevron, where it might have done that over a year ago when Chevron was still in effect. Now, San Francisco doesn't really rub the EPA's nose in the fact that it can no longer have deference. And the only time that San Francisco does cite Loper-Bright, which was the case overturning Chevron dealing with the fishing regulations last year or last term, it talks about when Loper-Bright really just reiterates standard interpretation of legislative interpretation. The idea that when you have a regulation that's or a policy that's imposed or enacted contemporaneously with the passage of a statute, that should be given some degree of consideration. And the reason why San Francisco raises that is because until in the beginning days of the Clean Water Act, the EPA would impose only numerical effluent limitations, such as those I described affecting the miners up in Alaska. So several times in its opening brief, San Francisco cites Loper-Bright for the assertion that only or that interpretations of a statute and policies interpreting a statute that are contemporaneous with the passage of the statute should be given weight unless the agency has good reason for showing why it's gone off in a different path lately. And it says that EPA hasn't done that. So that's the extent that Loper-Bright and Chevron are into this case. Not really a big deal and not really raising any new statutory interpretation issues or tenets, except for the lack of any argument about Chevron deference being have anything to do with anybody right now.
Thank you very much. We have a question about one of the four cases that we just kind of briefly touched on as well, the 1988 attorney's fees case. And our questioner wants to know if we predict it's going to be a 9-0 win. I'll confess I don't have a lot of expertise here, but I'm going to turn it over to Matt, who I know knows something about this case.
Yeah, sure. Thank you. This is the case that I'm tracking the closest, being a state attorney, because we oftentimes are faced with cases where people get preliminary injunctions. And, at the federal level, it's hard to contemplate that it's easy to change a law, but at the state level, it's not as hard. And so oftentimes, if there is a law that is enjoined, and even if we think that it's constitutional and that it's lawful, oftentimes it's frankly easier to do a legislative fix than endure a 2-year appeal to prevail on your preliminary injunction. So I think the incentive, this is an important case in terms of from the states, are where are the incentives lying? Because as it is right now, the states are not very incentivized to do legislative fixes, and they're incentivized to instead litigate to the hilt. I doubt it'll be a 9-0 reverse in favor of the state, particularly because the split is actually lopsided in the other direction in favor of allowing fees even after only obtaining preliminary relief. I certainly would love if it were a 9-0 in favor of the state, but I don't know if that's going to be in the cards.
I'll say someone who's often litigating on the other side of the V here. I think it is a different situation, right, where the state has enacted legislation that solves the problem. And so it's a remedy that will apply equally to everybody. Something that we run into is often the state will cave and give our individual client relief right away, but then we're not achieving the kind of legal victory that would help other folks. It reminds me of a case we're litigating right now under CAFRA, which awards fees for parties who substantially prevail in civil asset forfeiture actions. But often in civil asset forfeiture cases, if you start fighting them, the government will settle or give you your property back. And so the question is kind of, is that substantially prevailing if the government is essentially agreeing and returning the property, or do you need the actual legal determination that you prevailed? So a somewhat similar issue, but it is a complicated issue of determining prevailing parties for attorney's fees.
Hey, Kirby. The only other thing I was going to jump in and say, one of the things I thought was interesting about not only this Lackey versus Stinney case, but also the Williams versus Washington case, I think we've seen an unusual lineup in some sense in terms of if you look at the amicus briefs on both sides, because in both of these cases, you have conservative, often conservative states on one side, conservative attorney generals, solicitor generals, and on the other side, you have conservative organizations supporting the other side. And I know in Lackey versus Stinney, the attorney's fee issue is driving that to a certain extent, but you're seeing that as well in Williams v. Washington. So I just thought that was kind of an interesting issue. You're seeing kind of a cross-ideological alignment in both of these procedural cases that have very important real-world impacts and will have impacts on whether and how cases are litigated in the future.
I agree. It is an interesting phenomenon. And I think also in many of these cases is then reflected by a similar split even among the, 6 conservative justices. I would welcome any other questions. We have some time for a few more if anybody else has any questions. We have another question that I don't feel equipped to answer, but a prediction for maybe Zach, you can help us out with that. But the administrative exhaustion case, how that will play out, a prediction of how that will come down.
Well, I joke. I think my glass ball is broken these days. I haven't been very good at hitting the nail on the head. But I will give a shout out to Matt in his amicus brief in the Williams versus Washington case about the power of Congress to require state courts to hear certain types of cases. I think that's a very important issue. It gave me flashbacks to my Fed courts class in law school. But I think it's a very important, very real issue right now. And I thought that was an excellent amicus brief that Matt wrote in that case.
Well, very, very much appreciated. We were more focused on the oddity of having the U.S. Congress dictate to state courts exactly what the jurisdiction of state courts is. I think that's a fairly odd proposition for us in the state that the U.S. Congress can, through Section 1983, dictate the scope of our independent court system. So we'll see. I think it's Justice Thomas has written about this. I believe it was Haywood, a 5-4 decision. So we'll see if this gets any interest from folks.
Great. Well, if we have no other questions, we're coming in pretty far under time here, but I'd like to thank you guys all. This was great, and I'll turn it back over to Nate.
Well, as always, an embarrassment of riches on today's panel and a great discussion. We want to thank, special thanks to Kirby, who had to do like double duty and had to deal with a technical issue. Really appreciate you guiding the conversation. But to you and to our panel, we really are grateful for all of your valuable time and expertise this afternoon. For our audience, you can send feedback to us, certainly welcome, at info@fedsoc.org. Have a great day. We are adjourned.